All right, good morning, everyone. Today is Wednesday, March 25th. This is Family Law Matters legal team discussing the current issues of COVID-19 and how it impacts your family law case. As always, as you're joining the call, please make sure that you are on mute. Feel free to send us any questions that you may have via the chat room. If you also are familiar with Zoom, you know that you can raise your hand and we'll give you an opportunity to ask that question if you don't want to type it. So let's get straight to it. So this session is a continuation of our prior podcasts, specifically concerning custody. I know that we've had, I believe, at least two so far, and they might have raised a little bit of controversy, or as I like to call them, some follow-up questions. So we've compiled a list of 6 major questions, or 6 major categories of questions that we think need to be addressed and require further dissection and more legal advice. So with that said, again, this recording is going to be recorded. It's approximately 40 to 45 minutes. It'll be posted on all social media sites. Please make sure that you ask us your questions. And I'm going to give the panel an opportunity to introduce themselves. I'm going to start with you, Gina. Tell us a little bit about yourself.
Thank you. My name is Gina Famalaro, and I am a partner at Family Law Matters. I've been an attorney for going on 23 years in May, 9 years in Orange County, and the balance here in Riverside County. Always done family law. I've never practiced in any other area of law.
Perfect. Thank you, Gina. Colleen, you are up next.
Good morning, everyone. My name is Colleen Robinson. I'm a family law attorney here at Family Law Matters. I've been an attorney now for 10 years, which is hard to believe. It's been a decade already. I have, for the most part, I would say 97% of my practice has been family law since I became an attorney. I started out in San Diego County. I have appeared all over Southern California, and it's a pleasure to be here this morning.
Awesome. Thank you, Colleen. And Kristy, you are up next.
Yes, good morning, everybody. I hope you're doing well. We are wishing everyone healthy and happy during these trying times. My name is Kristy Bergamo. I'm also a family law attorney here. I'm a senior attorney. I've been practicing 17 years exclusively in family law. I'm also have been certified minors counsel. So I have been appointed by judges to represent children in court, and I'm just happy to be here today. Thank you.
Thank you, Kristy. I am Bashor Shahada. I'm also an attorney at Family Law Matters. I'm the managing partner. I've been practicing for a little over 2 years now, but as always, I will moderate, and I'm joined by over decades of legal experience. So Gina, I'm going to start with you. One of the biggest questions that we have received is, I've been told that I've been exposed to coronavirus, and I am the non-custodial parent. The other side, after finding out that information, won't let me see the children. What can I do?
Sure. I think that the governor's order and the court orders has caused some anarchy in the state of California. I think there's a lot of confusion, and unfortunately, I think that our opinion that the governor's order trumps the family law order has caused even more confusion. So part of the purpose of this video today is to clarify our position and to clarify what I think people should do and what we as a panel think people should do if they're having custody issues. So if you've been exposed to COVID-19, or you think you've been exposed to COVID-19, I think there's a two-parter here. The first part is, as always, our advice is to think of your children first, think of the big picture, and think of the situation in light of your relationship with the other party. The goal is always to co-parent. The goal is always to, if you're the husband or the father, to be able to walk your child down the aisle if you have a daughter in a few years. The goal is to be able to attend the high school graduation. And these situations, these especially trying situations, these very confusing situations that the times we're in right now, it's not to take advantage or to one up the other. It's to try to use this opportunity to work together and to improve your relationship. This is a long-winded way of saying, if you've been exposed to COVID-19, we would hope that you would look at the big picture, tell the other side that you've been exposed, get in writing an agreement that you will get makeup time, and perhaps forgo your visitation, get some video chat time with your child. Unfettered access is our hope to the other side, but there's no need for physical visitation. If for some reason the other side will not allow you to have makeup time in writing, or the other side will not allow you to have time with the child via Skype or video chat, then it's our advice, file an RFO. Go ahead right away, retain counsel, and get a court date on calendar so that you can get that makeup time. No one's going to fault you. No judge is going to fault you if you choose not to exercise visitation for the safety of the child. Does that answer your question, Bishoy?
Yes, I'm going to dissect it a little bit more, but I know you mentioned RFO. For those of us who don't know what that stands for, can you just give us what that stands for?
Sure, it's a request for order. So an RFO is a request for court relief. Anytime the parties can't agree on something, and again, it should always be in writing, but anytime the parties can't agree on something, it requires a court order. The vehicle to get that court order is by filing an RFO, or request for order.
Thank you. And on the advice that you gave, if I understand you correctly, you're asking the participants to first try to be cordial and try to coordinate some sort of either FaceTime or some sort of makeup time in the future. If that doesn't work, then again, can you walk us through what they can do and what their avenues are? Sure.
So I think that the theme here for all of us is going to be a three-parter. Reach out to the other side, get an agreement in writing. If you can't get an agreement in writing, file for relief from the court. The agreement in writing would include makeup time, and it would include Skype or video or telephone time immediately. Doesn't have to be face-to-face, but there should be some sort of electronic visitation.
Okay, and then I'm going to ask Kristy to chime in on this one. Kristy, can you, again, dissecting it a bit further, can you tell us the difference between, or how the situation would be different in terms of a custodial versus a non-custodial parent?
Yes, B. A custodial parent, well, I guess I need clarification. Which parent are we talking about being exposed?
So let's start with the non-custodial parent first being exposed.
So it's what Gina said, that you should be able to receive unfettered access by way of some electronic means or phone means, and then makeup time has to be included in any agreement that we reach and has to be understood by the custodial parent. If those issues are not resolved, then you need to file a request for order immediately, so that and what we can do in the meanwhile is keep reaching out to the other parent saying, look, we need FaceTime, we need makeup time. And that starts to become your evidence for something later on down the road when we file our RFO, when we finally get back to the court system. Family Code Section 3040 states that the court is going to favor parents who allow for frequent and continuing contact of the other parents. So I believe that even asking for the makeup time is one thing, but I think that you can also ask the court to consider the custodial parent's behavior in this situation for a basis of a modification of the visitation entirely. So those are the questions and issues that we have to deal with with potential clients on a case-by-case basis. So that answers who's the non-custodial parent. So the custodial parent, and have they been exposed? Is that the distinction here?
Yes.
Well, more than likely the child has been probably exposed as well, because of, you know, the amount of time that they spend together. I would assume that they're probably exposed too. I think in that situation, you know, you need to think of the health and safety of yourself, well, of the child predominantly, and you need to file an RFO to, you need to give unfettered access to the non-custodial parent, number one. Same rules apply. Give unfettered access, you know, let them know that they will get makeup time. We can put it in writing. And then I think you also need to file a request for order explaining why you've retained the child in case the other side, you know, wants to paint a different picture, and file an RFO saying that you've kept the child for them and so forth. I think we need to be proactive during these times. And I think if, in fact, later on down the road, it all works itself out, we can simply take that matter off calendar. But I think anyone who's retaining the child, I think we also need to file a request for order in case the other parent goes to court or files something saying you're not being cooperative. It just keeps everything clean in that regard.
So Kristy, to clarify, if you are the custodial parent and you're worried about the safety of the child, your recommendation is either get an agreement in writing or file the request for order. Is that a fair summary?
Absolutely, absolutely.
Thank you. And then Colleen, I'm going to ask you a couple of questions here. For parents who have 50-50 custody orders, where one parent believes that their house is safer than the other, how do they resolve that issue?
I think this one's slightly different than the two examples that Kristy and Gina were talking about, because I think that the 50-50 custodial parents, one, that kind of custodial timeshare requires more communication usually, because there's more exchanges that are occurring, and that if you decide to withhold the child, that you may be under additional scrutiny under that circumstance, especially if you're not exposed and you have a suspicion, or you're not sure what the other house is like. Our recommendation under those circumstances is, well, one, just as with every other case, we got to communicate with the other parent. This is the time to try to communicate, work something out, get something in writing temporarily. This is just to bridge the gap until the shelter in place is no longer in effect and we are returning to some sort of normalcy than everybody where we are currently. And if that fails, then and also offering a unfettered access via FaceTime and phone calls, whatever the situation is, offering makeup time when this is over. And I think also, if all of those things fail, we're going to need to file an ex parte and see what the court does. You need to get some sort of court orders in regards to a 50-50, and you decide to withhold the child for whatever reason regarding the shelter in place and your suspicions of the child not being or being in an unsafe situation. I mean, the whole purpose right now, we all have to look toward the bigger picture, as Gina was saying, and the whole purpose of this shelter in place is just to try to, one, flatten the curve, which is something we keep hearing most often, and also keeping everybody safe, keeping everyone healthy, and preventing the spread of the COVID-19 even further. But this is the time that we really need to try to put our differences aside, work on our co-parenting relationships. Probably applies to even married people as well. We're all in close quarters. It's all going to require us to work together so we don't to decrease conflict. But a 50-50 is slightly different in this situation, and we're going to need some court orders because we believe that they're going to be under closer scrutiny with the court.
So if I understand you correctly, with the fact that it's a 50-50 agreement, it kind of adds a third prong to what we've been talking about, which is So again, to summarize what you just said is you either follow the court order, or you get an agreement in writing, or you file for a request for order, but that request for order could be on an emergency basis. Is that fair to say?
That's true. It's our understanding that the courts are still hearing ex partes. I'm not sure what the court's going to do, if they're going to grant them at that time, but at least we, at this time, we get something into court and then file an RFO as well and reserve our place in line with the court, explaining what had gone on during this time of shelter in place, because the idea is when we get to court, the shelter in place is no longer going to be in effect.
Thank you. Gina, do you have anything to add to this?
Yes, and that is that, as we've talked about multiple times, this is unprecedented, the situation that's going on. And what we as attorneys can tell you from our experience is that judges are different. One judge in Hemet may have a different interpretation of what shelter in place means than a judge in Riverside. One judge, the same judge in Hemet, may have a different interpretation of two parties who act exactly the same on the same day. In other words, the court's going to examine the facts case by case, and they may decide that withholding the child was the correct thing to do, was the medically responsible thing to do, or the court could find out that, or could find that that it was in bad faith. Let me put it that way. In other words, just because it's our legal opinion that the governor's orders supersede state court orders as far as visitation goes, doesn't mean when all this plays out that that's how things are going to fall into place. It could be half of the state comes down one direction, half of the state comes down the other when we go to court. The point is this: protect yourself. If you're going to take any action whatsoever with regard to visitation, if you're taking the position that your child is unsafe, if you're taking the position that you're going to follow the governor's order, that's fine. Just protect yourself by following the strategies we told you before. Meet and confer with the other party. Get an agreement in writing if you can. Give unfettered access to the other side. Provide makeup time to the other side. But also what we're saying is protect yourself and file an affirmative request for makeup time for the other party. It cannot hurt, and it could be the difference between the court looking at you favorably or unfavorably. Again, we just don't know how things are going to play out in 6 months. And that's when all this is going to be resolved.
And Gina, just from a technical perspective, how would requests for orders be filed with the current shelter in place order? How are those filed?
Sure. That would be just like any other request for order. You'd retain counsel. It's going to be very difficult to do these things on your own these days because the courthouse is closed. It's closed to the public. And so going down to the courthouse and just filling out a form is no longer possible. An attorney has access to the courthouse even though they're closed. So you would file paperwork with the court. You get a court date. It may be a little bit further out, but it's really not about when the court date is. It's about getting your position on the record, getting it in writing so that in 3 to 6 months, the court knows what your position was and why you did what you did. You didn't do it for one-upsmanship. You did it because you were acting in good faith and you were concerned about the safety, health, and welfare, not only of your child, but the parties, other household, the people in your household, and let's face it, the community.
Thank you, Gina. And Kristy, I have the second question is more for you because I think you have a current case on that track. And the question is, what if the custodial parent is unavailable, whether hospitalized or out of the state or out of the country? The point is the custodial parent is unavailable. What do I do?
You need to file a request for order based on the circumstances. You need to tell the court, the other parent's unavailable, I need sole physical custody. I think you have to affirmatively do that and explain the circumstances. I mean, what we're hearing is that The hospitals are going to be overflowing with patients. It could potentially affect your specific circumstance. And again, I think you need, as Gina aptly pointed out, you need to be proactive. You need to protect yourself, and ask for these orders. And it is uncharted territory. I'm filing one as we speak, and either the court will grant the ex parte request or not, but at least, and set it to a hearing at some later date, but at least you've affirmatively protected yourself from scrutiny later. Because Gina is right, we don't know how the courts are going to feel about this all day. And I know I sound like a broken record, and I think I've said it on every podcast we've done that was about custody, is that, you know, this is a temporary situation, but the courts are going to look at about how you behave during it. And I would go one step further to say that if you did act in bad faith, it is a basis to modify your custody orders. It's kind of that saying, you know, you win the battle, but you lose the war. And that's, I can't stress that enough. But I think affirmatively protecting yourself from that scrutiny should definitely be done, for sure.
Thank you, Kristy. Colleen, do you have anything to add to that?
No, I think that was very, very well put, Kristy. I like that. Win the battle, but you lose the war. And I think that this is the time that this is not to be a custody grab and take advantage of the situation, that we have to think of the long-term ramifications of our actions today and whether or not that's going to serve us in the future and our children in the future.
Thank you, Colleen. And I do have a question here from one of the participants. And it states, in the case where both parents are exposed to COVID-19, would it be better to get the law officer to enforce the existing order? And would that be better than filing a request for order?
I'd like to answer that. Now we're getting the police officer exposed to COVID-19. There was something on Drudge Report yesterday that said that one person can infect 59,000 people. I don't know if anybody saw that. And again, I think it goes to the bigger picture. What's the harm with and let's say that you are exposed to COVID-19 and the other parent's exposed to COVID-19. Just because it doesn't, it's not life-threatening to children doesn't mean that your child can't be sick. Wouldn't it be better just to let the child in these trying times stay in one home, get an agreement in writing that the child can stay with one parent, whichever parent is better to care for the child during this time? Maybe you're sick now and the other party's sick later on. Maybe you're neither one sick. I don't know. But can't we just get an agreement in writing? And if not, again, file the RFO. But yes, it is your right to go there with the police. The question becomes is, what message are you giving your child? What message are you giving the other party? What message are you giving the court if you do have to go to court and litigate? There's nothing that the courts hate more than you showing up with the police and exposing your children to that kind of acrimony over wanting to spend time, wanting to love your child, right? It's the opposite message. The message is, I care about you, I want to spend time with you, and then you bring the police, which is a scary situation, and it's incredibly confusing for children. So try to reach an agreement, try to get it in writing, and if not, again, file an RFO. That's, I think, the best advice we can give.
Thank you, Gina. Colleen, anything? I know, Kristy, I have one more question that I'm going to ask you to answer, and I'll ask you to add to that. Colleen, do you have anything to add?
Nope. I think these Kristy and Gina have said it best.
Okay. Kristy, you have something to add, please.
I do, to what Gina stated about the police and the trauma to the child. I will again reiterate that a part of my practice has been representing children in courts. And I'm their advocate, and I can't stress enough what that level of acrimony does to these children, not just in the situation, but the long-term effects of that sort of witnessing those sorts of events. They are scared. They aren't in school. I mean, just put this in perspective. Gina said, look at the big picture here. And it really involves the protection of your children right now. They're hearing COVID-19. It's, it sounds like doomsday. I mean, this is not the time to be involving the police. We are here for you. We can certainly reach out to the other side. We will try our best to get some agreement, some understanding. And it really starts though with, and I think Colleen said this the other day, it starts with reaching out to the other parent. How exposed are you? Or, I mean, there's a lot of suspicion about who's exposed. And, I think we just really need to be mindful of the safety issue, the health issue. This is not just exposure, as Gina pointed out, between you, yourself, your child, the other parent. This is communities that could possibly be exposed. So I think everybody needs to keep that in mind right now.
And Kristy, perhaps is it a good idea that both parties agree to get tested for COVID-19?
Yeah, I mean, that's a solution. That's a solution, but remember too that it's my understanding that the tests are few and far between, and do we want every parent to go out and test because maybe they think there might have been, I think we need to be mindful again of the community and how many resources we have. And if yours is at a level where you're showing symptoms or they are, yes, but just to go out and tell everybody like blanketly go test, and if you don't test positive, then exchange the child, I think we're missing the point here. The point is that we haven't even seen the wave that is coming with respect to who's going to be sick, who's going to be in the hospital. And again, we have to look at the big picture here. And if all else fails, contact your attorney, hire an attorney to navigate you through this process.
Thank you, Kristy. And Colleen, we did just receive a question concerning mediation, and the question reads, will mediation for child custody be postponed?
So that could be two different ways. One, if you're referring to child custody evaluation, child custody recommending counseling, that's through the Riverside court system, or family court services that's offered through the San Diego court system. As of right now, through the time period that the court is closed, which we know as of today is April 3rd, that those appointments, as our understanding, are going to be rescheduled. However, as we kind of discussed yesterday, there are other options available for you to still move your case along and get some sort of recommendations or even agreement regarding child custody. One is that you could try to work it out between the parties through your attorneys. You could go to a mediator for those. You can also hire a private child custody evaluator who, my experience, they used to work for family court services or for child custody recommending counseling, and they're available too. I was just on one of their websites that they're doing all of their appointments through Zoom right now. So if you don't want to wait, there's still options available to go through those outside of the courthouse to get that kind of resolution. Both parties would have to agree to do that. And then there's the cost involved with that, but there are other options and waiting for the courts to resume business as usual.
Thank you, Colleen. Kristy, this next question is for you. It's slightly related. It's not specifically child custody, but it has to do with child support. And it reads, I've experienced a significant disruption in my pay. I haven't been laid off. How do I appropriately reduce my child support payments without repercussion?
We need to file a request for order immediately. And what that will do is that when we file it, it will reserve retroactivity. We're not going to get into court. And I know my clients have been reaching out to me saying, I can only afford this much. I can't afford that much. First, it's a conversation you need to have with the receiving parent of the support. Say, look, I've lost my job. I'm significantly my pay is significantly reduced, and you have to advise them. And if you're our client, certainly we'll reach out to the other side to advise them of that. I've received letters from other attorneys advising of that. But I think where we are more cautious, I don't see the request for orders being filed. And I think that you need to file those immediately, because what you're feeling about what is reasonable to pay under the circumstances may differ than theirs. So when it's all said and done, if you haven't filed a request for order to preserve the modification of the support during this time period, then it could be devastating to you. You could owe significant arrears. So I think you reach out. I think you come to a stipulation about it, and maybe both sides agree on what's reasonable. But if there's no written agreement about what's to be paid during this time period, there has to be a request for order filed so you preserve retroactivity.
Thank you, Kristy. And with that said, I just want to go back to the theme to make sure that our participants understand. And it's that if you're running into issues concerning custody and visitation amid the COVID-19 and the shelter-in-place order, number one, we ask that you reach out to the other side and be cordial. Think ahead. Think for the future. Don't think of the here and now. Try to get an agreement in writing, even if it's just temporary, to get us through this. Otherwise, if you're and make sure that you're open to make up time in the future. Make sure that you're open to visitation via Skype or FaceTime or Zoom or whatever avenues you have. Otherwise, if all of those don't work, then file immediately for the request for order. And keep in mind that we also indicated that if you have a 50-50 custody order in place, this may require you to file for an emergency request for order, for an ex parte is what we call it. The last thing is, if you suspected the other side, if you know that the other side is unable or unavailable to care for the child, please, that's grounds for an emergency filing. So again, we urge you to consult with an attorney and speak with your attorney. We urge you to be cordial. We urge you to, again, think for the future. If you have any questions, that's what we're here for. Feel free to give us a call or shoot us an email. If you have any additional questions, please make sure that you also reach out to us. In case you don't have the phone number, it's 951-587-0505. Or you can reach us at info@temeculadivorce.com. We'll be more than happy to set some sort of consultation. Or if you're an existing client, feel free to call in and ask to speak with your legal team, and we'll give you guys more guidance. I really appreciate the legal panel taking time out of their day again to talk about this topic as it evolves. I mean, we're a week into it now. The orders were issued last Thursday, so tomorrow will be exactly a week, and there are some uncertain times ahead, but we'll continue launching and posting these podcasts amid COVID-19 crisis, and we'll keep you guys updated and give you direction along the way. So I really appreciate everybody joining. Again, if you have questions, send them to us. Otherwise, this podcast will be posted on our YouTube channel, website, and our social media. Thank you all again. Thank you, Colleen, Gina, and Kristy. And I really thank the participants for taking the time out of their day. You guys have a wonderful day. God bless us all and keep us safe.
Bye.
Bye-bye.